I found out my HOA was fining me thousands of dollars when my bank account was suddenly garnished. And that was the moment I realized these people had declared war without even knocking on my door. My name is Vincent Oates, and I had been living peacefully in my modest 3-bedroom house in Chandler, Arizona, for about 8 months when everything went sideways. I worked as a software developer from home, kept to myself mostly, and genuinely thought I was doing everything right. The neighborhood was quiet, the streets were clean, and honestly, I barely noticed the HOA existed until they made themselves impossible to ignore. It started on a Tuesday morning in March when I checked my banking app over coffee and saw a withdrawal I definitely did not authorize. $5,200. Gone. Just vanished from my checking account with a notation that read HOA Lien Collection Suncrest Properties. I stared at my phone screen, convinced there had been some kind of mistake or fraud. My hands were shaking as I immediately called my bank, and after 20 minutes on hold with increasingly anxious music playing in my ear, a representative named Jennifer confirmed that yes, the withdrawal was legitimate. Apparently, the Suncrest Meadows Homeowners Association had placed a lien on my property for unpaid fines and had the legal authority to collect. "What fines?" I asked, my voice rising despite my best efforts to stay calm. "I never got any notice about fines." Jennifer was sympathetic, but ultimately unhelpful. She explained that once a lien was recorded with the county and proper legal procedures were followed, they could enforce collection. She suggested I contact the HOA directly to resolve the dispute. I hung up and immediately started digging through every piece of mail I had received in the past year. Nothing. Not a single letter, notice, or warning from the HOA about any violations or fines. My mailbox was at the end of my driveway, clearly visible and functional. I got bills, advertisements, and the occasional package slip without any issues. There was absolutely no reason I should have missed multiple certified letters or warnings if they had actually been sent. The HOA management office was located in a strip mall about 3 miles from my house, wedged between a nail salon and a tax preparation service. I drove there that same afternoon, my stomach churning with anger and confusion. The office was small and cramped, with fake wood paneling and motivational posters that felt deeply ironic given the circumstances. Behind the desk sat a woman who introduced herself as Deborah Winters, the HOA president. She was probably in her mid-50s, with severely highlighted blonde hair pulled back in a tight ponytail and reading glasses hanging from a beaded chain around her neck. She looked up from her computer with an expression that managed to be both bored and condescending at the same time. "Can I help you?" she asked, not bothering to smile. "I'm Vincent Oates from 847 Meadowbrook Lane," I said, trying to keep my voice level. "My bank account was just garnished for over $5,000 by this HOA, and I have absolutely no idea why. I never received any notices about fines or violations." Deborah sighed heavily, as though I was inconveniencing her by existing. She typed something into her computer, her long acrylic nails clicking against the keyboard with irritating precision. "Yes, Mr. Oates. You have accumulated quite a bit in violation fines over the past 6 months. Let me print out your statement." The printer behind her whirred to life, and she handed me 3 pages of itemized charges. I scanned the list with growing disbelief. There were fines for my trash cans being visible from the street, fines for having my garage door open for more than 30 minutes, fines for lawn maintenance issues, fines for unauthorized exterior paint color, and even a fine for having a decorative garden gnome that was apparently not in compliance with community standards. "This is insane," I said, my voice louder than I intended. First of all, I never received notice about any of these violations. Second, half of these are completely ridiculous. I'm not allowed to have my garage door open. I work on projects in there. And what's wrong with my lawn? I mow it every week. The CC and Articus are very clear about community standards, Deborah said, her tone suggesting she had given this speech 1,000 times before. All homeowners receive a copy when they purchase their property, and ignorance of the rules is not an excuse for violations. We sent multiple notices to your address. I never got them, I insisted. Not a single one. When were they sent? Can you show me proof of delivery? Deborah's expression hardened. We send notices via regular mail. We're not required to use certified mail for initial violations, only for the final notice before lien filing, which was sent certified and you signed for on February 15th. I absolutely did not sign for anything on February 15th, I said. I was out of town that entire week visiting my brother in Denver. I can show you my plane tickets. For the first time, Deborah looked slightly uncertain, but she recovered quickly, folding her hands on the desk with an air of finality. Regardless, the fines are valid, the lien was properly recorded, and the collection was legal. If you have concerns about the process, you're welcome to request a hearing with the HOA board, but that won't stop the collections process. I left the office feeling like I had been punched in the gut. This could not be legal. There had to be some kind of recourse when an organization could just drain your bank account without proper notice or due process. I spent the rest of the day researching Arizona HOA laws, and what I found was both enlightening and infuriating. Arizona revised statutes had very specific requirements about HOA enforcement procedures. They were required to provide written notice of violations, allow homeowners time to correct issues, provide notice of fines, and follow strict procedures before placing liens or collecting money. From what I could tell, my HOA had skipped pretty much every step. The next morning, I contacted 3 different attorneys who specialized in HOA disputes. The first 2 were sympathetic but wanted retainers I could not afford, especially after having $5,000 drained from my account. The third attorney, a man named Robert Chen, agreed to take my case on a partial contingency basis after reviewing the documentation I had gathered. "This is pretty egregious," Robert said during our initial consultation at his office in downtown Phoenix. He was younger than I expected, probably in his late 30s, with wire-rimmed glasses and an intensity that made me feel like he actually cared about the case. If they really didn't provide proper notice and forged a signature on certified mail, this is not just a violation of HOA procedures. It could be fraud. "So what do?" I asked. "We file a lawsuit challenging the lien and demanding a full accounting of their enforcement procedures. We'll also need to get records from the post office about that certified mail signature. If someone forged your name, that's a federal crime." Over the next 2 weeks, Robert filed a comprehensive complaint in Maricopa County Superior Court, and I personally went to the post office to request records for the certified mail that was supposedly signed for on February 15th. The postal worker was incredibly helpful, pulling up the tracking information and printing out a copy of the signature. When I saw it, my blood went cold. The signature was nothing like mine. It was not even close. Someone had literally scribbled something vaguely name-shaped and claimed it was my signature. "This isn't me," I told the postal worker, showing her my driver's license and signing my actual signature for comparison. "Yeah, those don't look anything alike," she agreed. "You might want to file a report about this." I took the documentation to Robert, who immediately added mail fraud to our complaint. He also suggested I file a police report, which I did that same afternoon at the Chandler Police Department. The officer who took my statement seemed interested but non-committal about whether they would actually investigate. He filed it as suspected fraud and said a detective might follow up. Meanwhile, life in my neighborhood became increasingly uncomfortable. Word had apparently gotten around that I was suing the HOA, and some of my neighbors were not happy about it. I came home one afternoon to find a note tucked into my door that read, "Stop causing trouble or you'll regret it," in anonymous block letters. My trash cans were knocked over twice in 1 week, and someone spray-painted "snitch" on the sidewalk in front of my house. I reported each incident to the police, but there was not much they could do without evidence of who was responsible. I installed security cameras around my property, which ironically generated another violation notice from the HOA claiming the cameras were not approved by the Architectural Review Committee. That notice, at least, I actually received, though it came via regular mail with no signature required. Robert advised me to ignore the new violations while the lawsuit was pending. "They're just trying to intimidate you," he said. "Don't give them any reason to claim you're not maintaining the property, but don't engage with their bogus notices either." The weeks crawled by as we moved through the discovery process. Robert subpoenaed all of the HOA's records related to my property and their enforcement procedures. What came back was shocking in its sloppiness. There were no copies of the violation notices they claimed to have sent me. The files contained only internal notes like "sent notice to 847 Meadowbrook," with dates but no proof of actual mailing. There were no photographs documenting the violations, no timestamps, nothing. Even more damning was what Robert found when he deposed Deborah Winters. Under oath, she admitted that the HOA used a property management company to handle most enforcement, but the management company's contract had ended 4 months ago. Since then, Deborah had been handling enforcement herself, often just walking through the neighborhood and making notes on her phone about properties she felt were not in compliance. "And did you actually send violation notices to Mr. Oates before assessing fines?" Robert asked during the deposition, which I was allowed to attend. Deborah shifted uncomfortably in her chair. "I made notes that notices should be sent. But did you actually send them?" "I believe they were sent, yes." "You have proof of mailing?" "I don't keep copies of everything." "Do you have any proof that any notice was sent to Mr. Oates before you assessed over $5,000 in fines?" There was a long pause. "The notices are sent according to our procedures." "That's not what I asked. Do you have proof?" "No," Deborah finally admitted, her face flushed with anger, "but I'm certain they were sent." Robert then pulled out the certified mail signature. "Is this your signature, Miss Winters?" Deborah looked at it for a long moment. "No." "You know whose signature this is?" "I assume it's Mr. Oates." "Mr. Oates has provided testimony under oath that this is not his signature. He has also provided evidence that he was out of state when this signature was supposedly made. So I'll ask again. Do you know whose signature this is?" "I don't know," Deborah said quietly. "Did you or anyone working on behalf of the HOA forge this signature?" "I don't know anything about that." The deposition revealed more problems with the HOA's procedures. Apparently, Deborah had been assessing fines without board approval, which was required under their own governing documents. She had also been setting fine amounts arbitrarily, rather than following the fine schedule laid out in the CC and Articus. The garden gnome violation, for example, was fined at $500, when the maximum fine for an architectural violation was supposed to be $50 for the first offense. As the case developed, Robert discovered that I was not the only homeowner who had been subjected to Deborah's enforcement regime. He found 6 other homeowners in the community who had similar complaints about receiving fines without proper notice. One elderly couple had their water shut off due to an HOA lien they knew nothing about until the water company informed them. A single mother of 3 had been fined repeatedly for her children's toys being visible in the front yard, even though the CC and Articus made no mention of toy restrictions. Robert suggested we reach out to these other homeowners and offer to include them in the lawsuit, or at least have them provide supporting testimony. Most were eager to help, relieved that someone was finally standing up to what had become an increasingly tyrannical HOA board. The actual trial was scheduled for late June, about 4 months after my bank account had been garnished. Those 4 months were some of the most stressful of my life. I was constantly worried about money since I was still down $5,000 and paying legal fees. My relationship with my neighbors was strained at best, with about half the community viewing me as a troublemaker and the other half quietly supporting me but too afraid to speak up publicly. The night before the trial, I barely slept. I kept going over everything in my mind, wondering if we had enough evidence, worrying about what would happen if we lost. Robert had assured me we had a strong case, but nothing was ever certain in court. The courthouse in downtown Phoenix was an imposing concrete structure that smelled like old carpet and industrial cleaner. Robert met me outside the courtroom looking confident in a crisp navy suit. We went over our strategy one more time before the bailiff called us inside. Judge Margaret Hartley presided over the case. She was probably in her early 60s, with silver hair and a no-nonsense demeanor that made me feel slightly better. She seemed like someone who would care about facts and procedures rather than just siding with whoever had more money or power. The HOA was represented by a lawyer named Thomas Briggs from a firm that apparently specialized in representing homeowners associations. He was polished and professional, but there was an underlying smugness to him that made my teeth grind. During his opening statement, he painted me as a homeowner who had repeatedly violated community rules and was now trying to evade legitimate fines through legal technicalities. Your Honor, the defendant purchased property in a deed-restricted community, Briggs said, gesturing broadly as if addressing a jury even though this was a bench trial. He signed documents acknowledging the CC and Articus and agreed to abide by community standards. The HOA has a duty to all homeowners to enforce these standards fairly and consistently. Mr. Oates received proper notice of his violations and chose to ignore them. The HOA followed all proper procedures in assessing fines and recording a lien. Robert's opening statement was more focused and factual. He laid out exactly what had happened: the fines assessed without notice, the forged signature, the lack of documentation, the procedural violations within the HOA's own governing documents. Your Honor, this case is about a homeowner whose due process rights were violated, Robert said. Mr. Oates never received notice of violations before fines were assessed. He never had an opportunity to correct any issues or contest the violations. Someone forged his signature on certified mail to create the appearance of proper notice, and the HOA board president acted unilaterally without board approval, assessing fines that exceeded the limits in their own governing documents. This is not about whether HOAs can enforce rules. This is about an HOA that ignored every protection homeowners are supposed to have under Arizona law. Over the next 2 days, we presented our case. I testified about never receiving notices, about being out of town when the certified mail was supposedly signed for, about my shock at discovering my bank account had been garnished. Robert introduced evidence showing the discrepancy between the forged signature and my actual signature. We had a handwriting expert testify that the signatures were clearly made by different people. Robert also called the postal worker as a witness, who confirmed that the signature on file did not match my signature, and that if I had not been home, the certified mail should have been returned as undeliverable rather than marked as signed. The other homeowners who had experienced similar issues testified about their experiences. The elderly couple described the nightmare of having no water for 3 days before they figured out what had happened. The single mother broke down crying as she described being fined hundreds of dollars for her children's bicycles being visible in the yard. When it was the HOA's turn to present their case, things fell apart quickly for them. Thomas Briggs tried to argue that their internal procedures were sufficient, and that the lack of documentation was just poor record keeping rather than evidence of improper notice. But under cross-examination, Deborah could not provide any concrete evidence that notices had been sent. Robert pressed her hard. "Miss Winters, you testified in deposition that you don't have proof that notices were sent to Mr. Oates. Has anything changed since then?" "No," Deborah admitted. "So you assessed over $5,000 in fines against a homeowner without being able to prove you ever told him about the violations. The notices were sent according to our procedures." "What procedures?" "You testified that you handled enforcement yourself after the management company's contract ended. What specific procedure did you follow to notify Mr. Oates?" Deborah's hands clenched in her lap. "I made notes of violations and mailed notices." "Can you produce copies of those notices?" "No." "Can you produce envelopes with postmarks showing when they were mailed?" "No." "Can you produce any physical evidence whatsoever that you sent notices to Mr. Oates?" "No, but I know I did." "Your certainty is not evidence, Miss Winters." The most damaging testimony came when Robert asked about the certified mail signature. Briggs had tried to avoid the topic, but Robert made it central to his questioning. "Miss Winters, you stated in deposition that this signature is not yours," Robert said, showing her the document again. "You also stated you don't know whose signature it is. Is that still your testimony?" "Yes." "But you used this signature as proof that Mr. Oates received proper notice before you initiated lien proceedings, correct?" "That was the certified mail receipt, yes." "Even though you knew or should have known it was not actually Mr. Oates's signature?" "I had no reason to think it wasn't his signature." "Did you compare it to any other documents with his signature?" "No." "Did you verify it in any way?" "No." "I received the signed receipt from the post office and filed it." "And when Mr. Oates told you he was out of town on the date this signature was supposedly made, did you investigate further? He could have been mistaken about the date." "Miss Winters, if you were told that a certified mail signature might be fraudulent, wouldn't a reasonable person at least look into it before proceeding with collections?" Deborah did not have a good answer for that. She stammered something about following procedures, but it was clear she had not actually followed any reasonable procedures at all. Judge Hartley asked several pointed questions of her own. "Miss Winters, according to the HOA's governing documents, fines above $250 require board approval. Is that correct?" "Yes, Your Honor." "Did you obtain board approval for the fines assessed against Mr. Oates?" "We had board approval for the enforcement policy in general." "That's not what I asked. Did you obtain board approval for the specific fines assessed against Mr. Oates, which totaled over $5,000? "Not specifically, no." "So you violated your own governing documents." "I was acting within my authority as president." "Your governing documents suggest otherwise." When both sides rested, Judge Hartley said she would take the matter under advisement and issue a written ruling within 2 weeks. Those 2 weeks felt longer than the previous 4 months combined. I tried to stay busy with work, but I found myself constantly checking my email and the court docket online for any updates. Finally, on a Thursday afternoon, Robert called me with excitement clear in his voice. "We got the ruling. You need to read this." He emailed me a PDF of Judge Hartley's order, and I read it 3 times to make sure I was understanding it correctly. The judge had ruled in my favor on every single point. She found that the HOA had failed to provide proper notice of violations, had failed to follow their own governing documents, had exceeded their authority in assessing fines, and had used a forged signature to claim proper notice had been provided. Judge Hartley voided every fine the HOA had assessed against me, every single one. She also ordered the HOA to refund the entire $5,200 they had collected, plus interest, plus my attorney's fees. The total came to over $7,800 that the HOA now owed me. But the judge went even further. In her written order, she stated that the evidence suggested potential criminal fraud in the forged signature, and that she was referring the matter to the Maricopa County Attorney's Office for potential prosecution. She also ordered the HOA to retain a professional management company and to submit all future fine assessments to the board for approval before collection could be pursued. I actually cried when I finished reading the order. 4 months of stress, anxiety, and financial strain finally felt worth it. I had won. Not just won, but completely and totally vindicated. The HOA had 30 days to comply with the court's order. Robert sent a formal demand letter outlining exactly what needed to happen and when. For the first 3 weeks, there was silence from the HOA. No payment, no acknowledgement, nothing. "They're hoping you'll just go away," Robert said when I expressed frustration. "Some people win judgments and never actually collect, but we're not going to let that happen." On day 28, with just 2 days left before we could move to enforce the judgment, a check arrived via certified mail from the Suncrest Meadows HOA in the amount of $7,832. There was no letter, no apology, just the check. I deposited it immediately, half convinced the check might bounce, but it cleared without any issues. That should have been the end of it, but the story continued in ways I had not expected. About 3 weeks after I received the refund, 2 detectives from the Chandler Police Department showed up at my door. They explained that the county attorney's office had indeed opened an investigation into the forged signature, and they had some questions. I invited them in and answered everything honestly. I showed them all my documentation, explained the timeline, and provided copies of everything I had given to my attorney. The detectives seemed thorough and professional, taking extensive notes and asking detailed follow-up questions. "Do you know who might have signed this?" one of the detectives asked, showing me the certified mail receipt. "I have no idea," I said honestly. The HOA president claimed she didn't know either. "Would you be willing to testify if this goes to trial?" "Absolutely." The detectives thanked me and left. I did not hear anything for another month, and I started to think maybe nothing would come of it. But then I got a call from Robert, who had been contacted by the prosecutor's office. "They arrested Deborah Winters this morning," he told me. "They're charging her with mail fraud and forgery." Apparently, the investigation had uncovered that Deborah had been the one who signed for the certified mail. She had done it herself, knowing I was not home, and then used that fraudulent signature as proof of proper notice. The detectives had obtained records showing that Deborah had picked up the certified mail from the post office on a day when I was provably out of state, presenting identification, but signing my name on the receipt. It was a stupid crime, made even stupider by the fact that she had apparently done the same thing to at least 2 other homeowners. The postal inspector's office got involved at that point because mail fraud is a federal offense, and suddenly, Deborah was facing both state and federal charges. The case made local news, with headlines like HOA president arrested for fraud, and Chandler HOA scandal reveals forged documents. My neighbors, who had been split on whether I was a troublemaker or a victim, now mostly came down on my side. Several people apologized for the cold shoulder they had given me over the past months. A few admitted they had suspected something was wrong with how Deborah ran the HOA, but had been too intimidated to speak up. There was an emergency HOA meeting in August to recall the entire board and elect new leadership. I attended out of curiosity, and the turnout was massive. Practically every homeowner in the community showed up, many of them angry and demanding answers about how things had gotten so out of control. A new board was elected, including several people who had been vocal about reforming HOA practices. One of the first things they did was hire a reputable property management company and establish clear procedures for violations and fines that included mandatory photographic documentation, multiple opportunities for homeowners to respond, and strict limits on fine amounts. The new board president, a retired accountant named Susan who lived 2 streets over from me, even personally apologized to me at the meeting. "What happened to you was inexcusable," she said in front of everyone. "This community is supposed to be a place where we all feel safe and respected, and the previous board failed at that completely. We're committed to doing better." I appreciated the sentiment, though I was not ready to actively participate in the HOA myself. I had spent enough time and energy fighting them. I just wanted to live peacefully in my house without worrying about arbitrary fines or power-hungry board members. Deborah's criminal case moved slowly through the system, as these things tend to do. She initially pled not guilty, but faced with overwhelming evidence, she eventually accepted a plea deal in November. She pled guilty to forgery and mail fraud, receiving a sentence of 2 years probation, 300 hours of community service, and permanent prohibition from serving on any HOA board in Arizona. She also had to pay restitution to the other homeowners whose signatures she had forged. The federal charges were dropped as part of the plea agreement, which was probably a relief to her since federal prison time was a real possibility. Still, having a criminal record and being publicly shamed in the local news was a significant consequence. For me, life slowly returned to normal. The money I had recovered helped me rebuild my savings and cover the expenses I had incurred during the legal battle. The new HOA board was professional and reasonable, focusing on genuine community issues like street maintenance and common area upkeep, rather than petty enforcement of minor aesthetic rules. I even got to keep my garden gnome, which had become something of a symbol of the whole ordeal. Several neighbors jokingly asked where they could get their own protest gnomes, and I saw a few pop up in yards around the neighborhood. Looking back on the whole experience, I learned a lot about standing up for yourself even when it feels hopeless. When my bank account was garnished and I realized the HOA had been fining me without notice, I could have just accepted it and tried to move on. A lot of people probably would have, either because they could not afford to fight or because they assumed the HOA must have had the law on their side. But I could not let it go. It was not just about the money, though that certainly mattered. It was about the principle that organizations cannot just do whatever they want to people without following proper procedures. Even HOAs, with all their legal authority and governing documents, have to follow the law. They have to provide notice. They have to give people a chance to respond. They have to keep records and act in good faith. When those protections break down, when someone like Deborah decides that her judgment is all that matters and that rules do not apply to her, the whole system fails. And when the system fails, sometimes regular people have to step up and fight back, even when it is expensive and stressful and uncertain. I also learned about the importance of documentation. If I had not kept records, if I had not had proof that I was out of town when that signature was supposedly made, if I had not gone to the post office and obtained copies of the tracking information, this case would have been a lot harder to win. Deborah could have claimed anything, and it would have been my word against hers. The support I received from other homeowners who had experienced similar problems was also crucial. Knowing I was not alone, having other people willing to speak up about their experiences, made a huge difference both in terms of evidence and in terms of moral support. It is easy to feel crazy or paranoid when you are fighting an institution by yourself. Having other people confirm that yes, this is actually wrong, this actually happened to me too, makes it much easier to keep going. My attorney, Robert, was instrumental in navigating the legal complexities. I could not have done this without professional legal help, and I was incredibly fortunate to find a lawyer who was willing to work with me on fees and who genuinely believed in the case. Not everyone has that option, and I recognize how lucky I was in that respect. The criminal prosecution of Deborah was satisfying in a way I had not expected. When we first filed the lawsuit, I was focused on getting my money back and clearing my name. I had not really thought about criminal consequences. But the fact that she faced real legal repercussions for forging signatures and committing fraud sent a message that this behavior is not acceptable. It is not just a civil matter or a dispute between neighbors. When you forge someone's signature and use it to take their money, that is a crime, and you should face criminal consequences. The reforms implemented by the new HOA board also gave me hope that some good could come out of this mess. The new procedures they put in place protecting homeowners from arbitrary enforcement would benefit everyone in the community. Future residents would not have to worry about coming home to find their bank account drained because someone decided they did not like the color of their mailbox. I still live in the same house on Meadowbrook Lane. My relationship with the HOA is cordial but distant. I pay my dues on time, I maintain my property to reasonable standards, and I keep my garage door open as long as I want when I am working on projects. No one has complained. My garden gnome still sits in my front flower bed, a little bit of whimsy that almost cost me $5,000. Sometimes I look at it and laugh at the absurdity of everything that happened. Other times I look at it and feel proud that I stood up for myself when it mattered. The entire experience taught me that homeowners associations are only as good or as bad as the people running them. They can be valuable organizations that genuinely help maintain property values and create pleasant communities. But they can also become vehicles for petty tyrants to exercise power over their neighbors, especially when there is no oversight or accountability. Arizona, like most states, has laws designed to protect homeowners from HOA abuses. But those laws only matter if people are willing to enforce them. The system relies on homeowners being informed about their rights and being willing to fight back when those rights are violated. That is a lot to ask of people who are already dealing with jobs, families, and all the other stresses of daily life. But sometimes it is necessary. If I could give advice to anyone dealing with a similar situation, it would be this. Document everything, know your rights, do not be afraid to get legal help, and do not let anyone tell you that standing up for yourself makes you a troublemaker. Sometimes being a troublemaker is exactly what the situation requires. The other homeowners who had been victimized by Deborah's scheme also received restitution as part of her criminal sentence. The elderly couple got back the money they had been forced to pay to restore their water service. The single mother got refunds for all the bogus toy violations. Several other homeowners I had never even met came forward after the news coverage and were able to recover money they had paid for questionable fines. In total, Deborah had improperly collected over $30,000 from homeowners in the community through her fraudulent notice scheme. Some of the fines went back almost 2 years, to shortly after she had been elected HOA president. It appeared that she had been operating this way for her entire tenure, just becoming more brazen about it over time. There was speculation in the neighborhood about what she had actually done with all that money. The HOA's financial records showed that the collected fines had been deposited into the HOA accounts, so it did not appear that she had been directly pocketing the money. But the HOA's expenses during her tenure had been unusually high, with large payments to vendors who were difficult to verify and bonuses that she had apparently approved for herself as compensation for managing the HOA without a professional management company. The new board hired a forensic accountant to review the books, and that investigation was still ongoing as of the end of the year. There were rumors of potential embezzlement charges, but nothing had been filed yet. Frankly, I was just happy to have my money back and to see Deborah removed from any position of power. If she faced additional consequences for financial mismanagement, that would just be icing on the cake. My life had pretty much returned to normal by the time the holidays rolled around. I decorated my house for Christmas, including some lights along the roofline and a wreath on my front door. Under the old regime, I probably would have been fined for the lights being the wrong color temperature or the wreath exceeding some arbitrary size limit. Under the new board, I received a friendly note saying my decorations looked great and wishing me happy holidays. It was a small thing, but it represented a huge shift in how the HOA operated. The organization went from being an adversarial force that looked for reasons to punish homeowners to being an actual community organization that tried to make the neighborhood a pleasant place to live. That is what HOAs are supposed to be, and it was refreshing to finally experience it. I ran into Susan, the new board president, at the grocery store a few days before Christmas. We chatted for a few minutes about how things were going with the HOA. She told me that membership in the Architectural Review Committee had actually increased because people were not afraid anymore of being on some kind of power trip. Homeowners were submitting improvement plans and getting reasonable feedback instead of arbitrary denials. "You really changed things around here," Susan said to me as we were wrapping up the conversation. "I know it cost you a lot, but what you did made it possible for us to reform everything. Thank you for that." I appreciated her saying that, even though I had not set out to be some kind of HOA reform crusader. I had just been a guy trying to get his money back and clear his name. But I suppose sometimes individual actions have ripple effects you do not anticipate. As I drove home from the grocery store that day, I thought about everything that had happened over the past 9 months. It had been one of the most stressful periods of my life, but I had come through it okay. More than okay, actually. I had stood up to an unjust system and won. I had helped other people in the process, and I had learned that ordinary people really can make a difference when they refuse to accept being treated unfairly. My house on Meadowbrook Lane felt more like home than ever as I pulled into the driveway. The security cameras I had installed during the height of the conflict were still there, but now they just made me feel safe rather than serving as evidence of harassment. My garden gnome greeted me from the flower bed, looking slightly ridiculous and absolutely perfect. I carried my groceries inside, grateful for the warmth and comfort of my own space, and grateful that I could enjoy it without worrying about what arbitrary rule I might be violating or what notice I supposedly should have received, but never did. The judge had voided every fine and ordered a full refund. But more than that, the whole ordeal had resulted in systemic changes that would protect everyone in the community going forward. That felt like justice. Real justice. Not just for me, but for everyone who had been victimized by a system that had lost its way. And while I would have preferred to never go through any of it, I could at least feel satisfied that something good had come out of a bad situation. The new year came, bringing with it a sense of renewal and possibility. The HOA drama was behind me, relegated to the status of a story I would tell at parties when the conversation turned to nightmare neighbor situations. I was just another homeowner in just another Arizona subdivision, living my life and working my job and enjoying the simple pleasure of coming home to a place that was truly mine. And if anyone ever asked me about that garden gnome in my front yard, I had one incredible story to tell them.